Today we're going to pull back the curtain on a legal dispute that erupted inside what seems like a totally ordinary homeowners association. It's a story about rules, about transparency, and about one secret meeting that turned neighbors into legal adversaries.
I mean, can you just imagine the tension in that hearing room? A witness is on the stand and has to say this about the board president. That one sentence. Wow. It just tells you everything you need to know about how personal and heated this whole thing got. It's pure courtroom drama.
But a moment like that, it doesn't just pop up out of thin air. This whole firestorm kicked off because of a disagreement over a single document, a proposed code of conduct for the HOA board. The very thing that was supposed to create harmony, well, it did the exact opposite.
And that really is the big question we're digging into today, isn't it? How does a simple debate over rules and procedures escalate into formal complaints, lawyers, and sworn testimony? Let's unpack how it all went down. Okay, so here's a quick look at how we got here. It all starts in April of 2023. Two new guys, Jeffrey Connell and Corey Cox, get elected to the board. Then, just a month later, we have this controversial closed-door meeting. Things simmer for a few months, and by November, a formal complaint is officially filed. That leads us to the big hearing in March 2024. So let's start with the guys who filed that complaint.
So you've got Connell and Cox, the petitioners. Their whole case is built on this feeling that from the second they got elected, they were being shut out. Everything they were asking for really boils down to one simple idea. A board's business should be out in the open.
You know, this quote from Jeffrey Connell's testimony just cuts right to the heart of it. He's on the stand, and he's basically saying, hey, we're board members, but huge decisions are being made, and we're completely in the dark.
And what's really crucial here is that he wasn't just saying the board wasn't transparent. He was saying it actually got worse after he and Corey Cox joined. He testified that he was being denied access to records, kept out of the loop, making it pretty much impossible for him to do the job he was elected to do.
Okay, so this code of conduct, what was the big deal? Well, the petitioners say it was just dropped on them in that closed meeting, and Connell saw it as nothing less than a gag order. Think about it. The board's own attorney is recommending this so the board always appears to act in unison. That sounds a lot like trying to silence any kind of public disagreement, doesn't it?
And this is where we get to the real legal meat of their argument. Connell's saying, look, talking about a code of conduct is just general business. It's not some super secret legal strategy that justifies locking the doors on homeowners. He felt like what he heard was the attorney's opinion, that this was a common thing, not the kind of formal legal counsel that would require total privacy.
All right, so that's the petitioner's side of the story. Now let's flip the coin and see what the board president and the community manager had to say. For them, this wasn't about being secretive at all. It was about following the rules and, getting some necessary legal training.
So the former community manager gets up and basically says, look, we have a system for this, and we've had it for a long time. They print 4 notices, post them in all the high-traffic spots, the office, the clubhouse, and even on both sides of the only gate in and out of the community. And they do it way more than 48 hours ahead of time. It was just standard procedure.
And then there's this email from board president John Ryder, which adds a whole other layer. Weeks before that meeting even happened, he's calling it a board training session for all of us. See, from his perspective, this wasn't some secret plot. It was a training session with their lawyer for the entire board, including the new guys.
And boom, here it is, the direct clash in testimony. Connell says he was frozen out. Ryder flatly denies it. He says no one was ever denied records or shut out of decisions, and then he adds, in fact, that would be illegal. You can't get a more classic he said situation than that.
And what about that code of conduct, the document that started all this? Well, the board's take was that it was basically nothing, just a draft, a simple document to talk about civility. And the second it became clear that it wasn't going to get unanimous support, they just dropped it. No harm, no foul. It was never enforced. So you've got two completely different stories, right? And the whole thing really just boils down to one single legal question. What exactly counts as legal advice? Because that definition is the key to justifying a closed-door meeting.
Okay, to really get what's going on here, we have to talk about something called an executive session. Under Arizona law, an HOA board can't just decide to meet in private for fun. It's only allowed for really specific reasons, and one of the big ones is, you guessed it, consulting with their attorney for legal advice. Which brings us right back to the million-dollar question for this hearing. Was that conversation on May 19th, the one about board training and a draft code of conduct, was that really legal advice? Well, the answer completely depends on who you ask. So check this out. This table really lays out the two completely different ways they saw this. The petitioners are on one side saying, hey, general training isn't legal advice, this should have been public. But the board's on the other side saying, whoa, wait a minute. Getting guidance from our lawyer on our duties and how to avoid getting sued, that is the very definition of legal advice, and it absolutely has to be private to protect attorney-client privilege.
You know, when you peel back all the layers of this one specific case, with all its drama, you start to see that it's really a window into a much, much bigger challenge. One that thousands of communities are dealing with every single day. It's like walking a tightrope.
And that's why a story like this is so important. Every single HOA is constantly trying to balance these things. You've got the public's right to know fighting against the board's need for private legal advice. You have the value of open debate clashing with the desire to look like a united front. It's a constant push and pull, and this case just puts all those conflicts right under a microscope.
So, after all was said and done, after all the legal back and forth, the judge said something really simple. It's this powerful reminder that behind all the rules and bylaws, these are just neighbors, people trying to live together and run their community. And maybe a little bit of grace could go a long, long way.
And that's really the question I want to leave you with. For anyone living in one of these communities, or really any community, where do you draw that line? How do you strike that perfect balance between a board's need for candid, private advice and a homeowner's absolute right to know what's going on? There's no easy answer to that one.